In early January 2019, Cryptopia was one of the busiest cryptocurrency exchanges most people had never heard of. Based in Christchurch, New Zealand, it had built its identity on breadth rather than prestige, listing hundreds of digital assets and attracting a global user base that relied on it for access to small, illiquid coins. Behind the interface sat the usual split between hot wallets that could move quickly and colder storage meant to stay out of reach. On January 14th, staff noticed suspicious activity that suggested a private key tied to the exchange's hot wallet infrastructure had been compromised. Within hours, the platform was placed into maintenance mode and trading was halted. The next day, police secured the premises as the incident shifted from a technical emergency to a criminal investigation and a potential insolvency event. What made the Cryptopia hack especially damaging was that it did not end in a single burst. Wallets connected to Ethereum and ERC-20 tokens became a focal point, with repeated, unauthorized withdrawals observed over subsequent days and weeks as the attackers continued to siphon assets. Estimates of the value taken varied depending on the snapshot used and the assets counted, but court materials later referenced roughly 30 million New Zealand dollars in stolen cryptocurrency. Independent blockchain analysis at the time produced figures in the same general range, and the exchange itself struggled to present a definitive accounting while systems were offline and confidence was collapsing. For ordinary account holders, the problem was simpler than the valuation debate. Deposits that had appeared as balances on a website were now scattered across addresses on public blockchains, moving in patterns that looked deliberate, opportunistic, and irreversible. As the exchange remained shut, the practical consequences came fast. Employees faced uncertainty, customers had no access to funds, and the company's public statements could not restore trust without proving that remaining reserves were secure. Even if some assets had been spared, the business model depended on continuous operation, and the interruption was not measured in hours but in weeks. In May 2019, Cryptopia was placed into liquidation, and Grant Thornton was appointed as liquidator. The story pivoted from a cybersecurity breach to a drawn-out forensic and legal exercise. Identify what was left, confirm what belonged to whom, and determine whether the law treated those holdings as the company's property or customers' property. That question mattered because it determined everything that followed. If the crypto assets were simply assets of the company, customers became unsecured creditors, competing with other claims in a standard liquidation. If the crypto assets were held on trust, then customers had a stronger claim to the specific coins associated with their accounts. The situation was complicated by how exchanges typically operate. Customers do not hold private keys on an exchange. The operator controls the wallets, and internal ledgers represent who is entitled to what. When that operator collapses after a hack, the internal database becomes evidence, not assurance. The liquidators needed legal clarity before they could distribute anything at scale, because a wrong step could trigger further litigation and delay. The case that emerged, Rusco and Moore versus Cryptopia Limited, in liquidation, became the legal spine of the Cryptopia aftermath. It dealt with two core issues: whether cryptocurrencies could be treated as property under New Zealand law, and whether those crypto assets were held on trust for account holders. In April 2020, the High Court of New Zealand concluded that cryptocurrencies were a form of intangible property, and that the digital assets held by Cryptopia were held on trust for the benefit of account holders rather than being owned outright by the company. The ruling did not reverse the hack, and it did not instantly return funds, but it reset the legal landscape. From that point, the liquidation became less about dividing the remains of a failed business and more about reconstructing and returning property that the court recognized as belonging to customers, subject to the practical reality that a portion had already been stolen and moved beyond reach. The technical work now had a different purpose. The liquidators faced a problem that resembled an audit conducted across blockchains, mapping Cryptopia's wallet infrastructure, separating assets tied to different groups, and reconciling on-chain balances with the exchange's records. Each step required repeatable proof, because any distribution would depend on confidence that a verified claimant's balance corresponded to identifiable holdings. At the same time, the criminal investigation remained in the background, constrained by jurisdiction, the pace of tracing, and the fact that visible transactions on public ledgers do not automatically reveal identities. The public could watch coins move, but turning movements into arrests and recoveries was a different kind of work, slower and often opaque. By the time the court confirmed crypto assets as property held on trust, the collapse had already become a multi-year process. What began as unusual wallet activity on a January evening in Christchurch had turned into a landmark ruling about digital property and a liquidation defined by forensic remediation. The next phase would be shaped by the mechanics of verification, the creation of asset-specific pools for distribution, and the long sequence of steps required before any meaningful return to account holders could begin. Following the High Court ruling, the liquidation entered its most labor-intensive stage. Grant Thornton began constructing a claims process that could survive legal scrutiny and technical verification at the same time. Account holders from dozens of jurisdictions were required to register, submit identity documentation, and link their historical Cryptopia balances to real-world identities. This was not a symbolic exercise. Each claim had to be matched against exchange records and then aligned with specific pools of remaining crypto assets, separated by currency type. Unlike a traditional liquidation where assets are converted to cash, Cryptopia's remaining holdings stayed largely in cryptocurrency form, meaning distributions would depend on on-chain transfers rather than bank payments. The stolen portion, however, remained outside that system. Blockchain investigators had already tracked the initial movements from Cryptopia's wallets into attacker-controlled addresses in early 2019. Those funds were gradually split, mixed, and moved through intermediary wallets, reducing the likelihood of recovery. While some addresses were publicly labeled and monitored, there were no major announcements of large-scale seizures linked directly to the hack. For affected users, this created a split reality. One part of their loss was legally acknowledged as their property and potentially recoverable through liquidation. Another part was functionally gone, visible only as historical transactions on a blockchain explorer. As the process continued, delays became a defining feature. Verifying hundreds of thousands of claims across multiple asset classes required repeated audits and court approvals. Each proposed distribution phase had to be justified, documented, and communicated. In parallel, the liquidators faced criticism from some creditors over costs, timelines, and the complexity of the process. Those tensions occasionally surfaced in court filings and public updates, but they did not alter the core legal framework established by the 2020 judgment. The assets that remained would be returned proportionally, currency by currency, as far as practical. Years after the hack, partial distributions began to materialize. By 2023 and 2024, Grant Thornton confirmed that significant sums had been returned to verified account holders, marking the first tangible conclusion for users who had been locked out since 2019. These distributions did not make customers whole, but they demonstrated that the trust structure recognized by the court could function in practice. Each transfer represented the end of a chain that started with a compromised private key, passed through insolvency law, and emerged as a precedent-setting exercise in crypto asset recovery. The Cryptopia case did not end with a dramatic arrest or a full recovery of stolen funds. Its lasting impact came from a slower outcome. It established that cryptocurrency could be treated as property under common law, that exchanges could hold those assets on trust, and that a hack did not automatically convert customer balances into unsecured claims. For regulators, liquidators, and courts, it became a reference point. For users, it was a prolonged demonstration of how technical failure, legal uncertainty, and operational collapse intersect in the cryptocurrency ecosystem. What began as a breach in January 2019 ultimately reshaped how digital assets are understood when an exchange fails, not through spectacle, but through years of procedural reconstruction and judicial interpretation.